Husbands can now take their wives' surnames if they so wish. That's according to a Constitutional Court ruling made on Thursday. Until this week, the law only allowed women to take their husbands' surnames, but not the other way around. The judges say this law came from colonial times and was unfair because it discriminated against men and reinforced only old gender stereotypes. Two couples challenged the rule, saying it was outdated and against the country's constitution, which protects equality. Now, let's explore what this ruling means, not only for gender equality and legal reform, but also for cultural identity in this country. To help us do exactly that, I'm joined by cultural expert Professor Musa and traditional leader Sekgothe Mokgoatsana. But before then, let us listen to just an excerpt from that ruling as it was being delivered.
In the case of men, they are deprived of the ability to assume their wife's surname if they so wish. In the case of women, the effects of the scheme are far more insidious. It is not merely so that they are deprived of the right to have their surnames serve as the family surname where their husbands wish to take that surname. It also reinforces patriarchal gender norms which prescribe how women may express their identity, and it makes this expression relational to their husband as a governmental and cultural default.
So that was Justice Teron of the Constitutional Court delivering that judgment a couple of days ago. Naturally, there's been wide-ranging debate across the country. Part of it has been rooted in traditions and culture. That's why we're having this conversation this afternoon. Let me start with you, Tate Mokgoatsana. Your reaction to this ruling, what are its implications culturally?
Good afternoon, listeners. Good afternoon to everybody. The ruling is it's a shame. It's a shame. It's an assault on African culture and practices, because never in the past have we had wishes of men expressing their desire to get married to their wives' surnames, or to be able to use wives' surnames. You remember, we are a patrilineal society. It's not a shame that we are a patrilineal society. We are aware, we accept the rights of women, we accept the issues of equality, but when it comes to marriage and conduct and social behavior in terms of marriage customs, we inherit the names of our fathers, and that's how also inheritance goes through, the succession goes through from father to son. Therefore, when we marry our wives, it is expected that they will take our surnames, and the children also take our surnames. If in the event of divorce, our wives want to choose to retain our surnames, we have no problem. But it is a problem that a man chooses to become somebody else, changes an identity that is common, because our common identity is the identity of your forefathers. Therefore, when you change it to become the identity of your wife, it means you are now belonging to a different family. And how do you respond to your own ancestors? Because here, our ancestors are also, we're dealing with ancestors from our father's line. Now, the ruling in itself, as I say, it's an assault on African culture. It's really embarrassing. It's a court of law. It's a judgment that has been made. But I think it's going to sow the seeds of discontent amongst African people. Yes, I know there are people who are fighting for feminine rights. They may applaud it, that it is equality, but the question of the name, a name has no equality. A name is inherited. You inherit the name of your forefathers.
Let me get the views of Professor Musa. Prof, you've also had the opportunity and occasion to consider that judgment out of the Constitutional Court. Just your overall thinking about it, what are its implications?
Well, it's a good judgment. The issue is that the Constitutional Court always looks at the Constitution when it takes decisions. And there's a provision in the Bill of Rights that says 9.3, that says that there can be no discrimination on the basis of gender and on the basis of marriage status and all other issues that are raised there. There was a legislation which prohibited males from assuming the surnames of their wives. Then, of course, the Constitutional Court did not invent this. There are couples that went there to court to dispute that legislation, to say it was discriminated against and limited the choices of the males that wanted to assume the surnames of their spouses, of their wives. Now, we must always remember that South Africa is a multicultural country. There are people who want to do this, and the Constitution have to enable them to do it because the Constitution cannot be prohibitive. So the Constitutional Court took that into account. You must always remember that in a multicultural country, there are various cultures that some of them we may not agree with, but there are people that are practicing those cultures, and we have to respect that. And I think the Constitutional Court took that into account. It's done in many other countries of the world, other cultures of the world, in Finland, in Japan, in West Africa. And of course, you also have the issues with the Mojaji and all of those kind of places. Where, for example, even among the Zulus, if you marry a Zulu woman from the Zulu royal family, your children become princes and they use the praise surnames of the Zulu royal family. So it's not something that is strange. You remember that Mtwana wa Pindangene, for example, would address himself as Makeba and Abezita, and his children have inherited that simply because his mother came from the Zulu royal family.
Yeah.
So it's not very remote, and the Constitutional Court has to create situations where people cannot be prohibited from expressing their choices in public or in private.
Dr. Mokgoatsana, many people have questioned the reaction from a cultural perspective, and the question, the way I seem to have made sense of it for myself, is that this is merely a door that is open for those who want to go through that door of starting to exercise this practice of a husband taking up the wife's surname after marriage. But it is not enforced, it's not forced on anyone, it's not peremptory. It was framed along the lines of if they so wish. So it leaves the question then, where is this threat coming from? Is it a threat based on not trusting the institutions of tradition and culture that you abide by to hold, despite this door being open, and for the people who live their lives according to that culture to continue to conduct themselves according to the customs of that culture, despite this other option being available? Do you not trust yourself? Do you not trust your histories and your traditions?
We trust ourselves, but African culture is vulnerable. You see, when it comes to the Constitution, they give you an option to choose a culture. How do you choose a culture? They give you an option to choose a language. How do you choose a language? And that is why African languages and cultures are dying. When you go to schools, African languages are dead, completely dead, because people have a right to choose. And when they're given that right to choose, they choose English. Therefore, when you give us this option, I understand it's not mandatory to everyone to do so. I understand it's a leeway for those who wanted to exercise that right. But I'm saying it's opening a door for the crushing and crumbling of African culture, because it's not going to be protected in any way. Every time if you make an argument, they will tell you the judgment makes provision for that choice.
Yeah.
And this man has made a choice. But then also we are going to have, this is also tied to the issue of local residents as well. It is in our culture that we marry, when I marry into X family, the bride lives with us. It's not a choice, it's mandatory in terms of cultural principle, because we are patrilineal, we are also patrilocal. Now, conversely, this is going to affect that, and then that will lead to disintegration of African culture. Why we are patrilocal is because it ensures that we live together to be able to practice a common culture that we can share and hand over to our children. But then when people make such choices, it's upset. It's going to be difficult.
Prof Xulu, you've made the point that this whole debate is actually misplaced, because you, and I think the Constitutional Court judgment does exactly the same at paragraphs 24 and 25, question even the whole concept of surnames being an African custom and tradition. Talk to me a bit more about that.
Well, surnames are very new in Africa, in sub-Saharan Africa, and among Black people, especially here in South Africa. If you read cultural history of Africa extensively over the past 1,000 years, for example, you become Shaga Kastanakon. Your identity is the identity of your father. What happened during colonial times, because they wanted to register people and to group them, then the prominent person in that surname would then be in that clan would then be turned into a surname, and then that's how they invented surnames, which were actually not all that widespread before the colonial era. There's a lot of other things that we tend to think that are part of our culture. Let me take the example of 11 cows for Lobola. That is a colonial invention. That was invented by Sir Theophilus Shepson in the 1850s for Zulus in Natal, and then in KwaZulu after that. And today we think that that's part of our culture. It's not. It's before then you paid lobola according to what you had, and if you had nothing, you'd still take and marry, and then keep a debt that in future when your first daughter gets married, then you'll be able to pay that. So it's then Shepstone made it transactional, and we think now that is part of our culture. It's not. And there's a lot of these, if you read the anthropology that have been invented by colonialists that we take as our cultures, when they are not.
Thanks for that, Prof. Let me quickly throw that question then to Ntate Mokgoatsana. Ntate Mokgoatsana, the court in its reasoning mentions what Prof Xulu is talking about, basically saying that this whole custom at paragraph 25, the custom that a wife takes the husband's surname existed in Roman Dutch law, and in this way was introduced into South African common law. What do you say to the argument that says you are fighting for a colonial tradition? There's no history of this tradition in our region in Southern Africa. In fact, the history is that the wife would, after marriage, continue to be referred to, of course, part of the new marital family, but with reference to their family. So the result being that if her maiden surname was Simelane, she would be Uma Simelane, La Simelane, even in reference post-marriage. What do you say to that?
I agree with him when he says surnames are a new invention, but names are commonplace. We have family names, we don't have surnames, and therefore when you marry, you are there to expand the family name, not the surname. Therefore, when the woman is married into my family, he's coming to expand my family name, not surname. And for this reason, when you come to Skukuneland, the majority of people have different surnames because they opted to use their grandfather's name. And to the extent that you would find in one family, they've got different surnames. But the truth of the matter, and because the surnames were there because the colonial master wanted to control the collection of taxes, to be able to enumerate and be able to be exact in terms of how many tax paying people are available in a particular district, so that when the native commissioner were to collect the tax, they would be able to count how many are liable for tax. But this is not the debate. The debate is we always have a family name. We've got a family wealth. We've got family fields. We've got a family inheritance.
Yeah.
And therefore, the woman becomes part of the group. Through marriage, she's integrated into a family, and therefore her name is also within the family.
Right.
And it's for that reason that in certain families, you also get a name that you inherit from the in-laws, that you are renamed because you no longer belong to your parents. You belong to a new family.
Yeah.
The surname issue, it's out of question. We actually do not have surnames.
All right.
We're keeping them because the legal system wants us now to do it.
All right, thank you for that. It's a fascinating debate. We're certainly not going to conclude it here this afternoon, and you get a sense that it will continue to rage over the next coming months, years, decades, who knows, centuries, possibly. That was traditional leader Sekgothe Mokgoatsana, and of course we were also joined by cultural expert Professor Musa Xulu.